In looking at the various theories of constitutional interpretation, I need to go with the moral fact theory. Where the Constitution says, for example, that cruel and unusual punishment should not be inflicted, this is a command from the authors of the Constitution to us not to be cruel. It's not a command that says, don't do those things that we living in 1790 would have judged to be cruel. It says, don't do those things that are cruel. Where the Constitution says that no person shall be deprived of life, liberty, or property without due process of law, this is a command from the authors of the 14th Amendment to us to establish processes that will protect people from losing their life, liberty, or property unjustly. It doesn't command us to set up processes that the authors of the 14th Amendment would have judged to be due process of law. It tells us to provide people with the processes that they are due. Now, why do I believe this? My first reason is that the authors of the Constitution, the Bill of Rights, the Reconstruction Amendments, believed that they were referring to moral facts. They believed that there was a real thing called a right to freedom of speech, that no person shall be deprived of. They believed that there was a real thing called cruel punishments that should never be inflicted. And they believed that there were real things called due processes and equal protection under the law to which each person was entitled. Evidence for this can be found in, among other places, the Declaration of Independence and in the political philosophies on which the country was founded. The Declaration of Independence speaks of rights that come from nature or nature's God, not from the beliefs of human beings. We don't have a right to be secure against unreasonable searches and seizures because George Washington and James Madison dreamed up this right. They would have scoffed at the claim that these rights came out of their own mind and had no existence independent of their thoughts. These are natural rights, not rights made by humans. We see it in the way that they wrote about these rights. They didn't say anything like, with our thoughts we hereby create a right that we will now bestow upon the population. They use phrases that only make sense under the assumption that these rights can be found in nature and are due our respect. These rights, quote, shall not be infringed, unquote, and, quote, shall not be violated, unquote. And the Ninth Amendment clearly states that there are rights still to be found, perhaps still to be discovered, that aren't listed in the Bill of Rights. In fact, one of the arguments that founders who opposed a Bill of Rights used against having such a list was the fear that by doing so, people will think that these are the only rights to be protected and others not listed would be violated. A second reason for preferring a moral facts theory rather than a belief of the founders' interpretation is that the latter requires assigning to the founders the arrogant presumption that they are the font of all wisdom and virtue. Given that the founders were fallible human beings, a beliefs of the founders' interpretation locks us into perpetuating their errors and injustices. The beliefs of the founders' method for interpreting the Constitution puts us, for want of a better term, under a dictatorship of the dead. In response to this argument, one can say that the founders provided us with an amendment process we can use to correct their mistakes. Unfortunately, one of those mistakes is that they gave us an amendment process that doesn't work. Out of the 27 amendments passed, 10 of them, the Bill of Rights, should properly be considered a part of the original Constitution. One, the 21st Amendment, repealed another one, the 18th Amendment, which nets nothing. 12 more are just adjustments to the bylaws, making small changes in procedures while having no effect on substance. The 3 that remain, the Reconstruction Amendments, were preceded by a civil war that left stacks of dead and injured from one end of the country to the other. So when it comes to substantive changes to correct the mistakes of the Constitution, our amendment process seems to be, first, enter into a long period of bloody violence. Second, the winner of that bloody violence can then force through substantive changes to the Constitution. It's hoped that we could find a better way. The final outcome is that we have, for all practical purposes, been placed under a dictatorship of the dead. We can't even petition them to change their mind. We can't reason with them. For all practical purposes, we're not permitted to govern ourselves and choose our own laws, because they, through their agents in the court, stand ready to veto laws they disapprove of, but which we have judged to be, borrowing a phrase from the Declaration of Independence, the most wholesome and necessary for the public good. My third argument for preferring a moral facts theory is that the phrase, "I was just following orders," is no defense for perpetrating an injustice. Every person and everything they do ought to be asking themselves whether their actions helped to establish a society that is just, peaceful, secure, free, and prosperous. Now, these are among the things to consider. This isn't a whole list of everything to be considered, but they will, in some circumstances, be the deciding factor in tilting the balance one way or another. This applies to enforcing and in interpreting the law. When the law commands injustice, morality sometimes allows, and sometimes requires, that one refuse to obey. My fourth argument is that in all matters of interpretation, philosophers advocate what's called a principle of charity. This principle states that, all else being equal, the true and rational interpretation is to be preferred over any other. Like in a trial where a person is presumed innocent unless the evidence shows beyond a reasonable doubt that they're guilty, in matters of interpretation, we are to presume that the author's or speaker's claims are true and rational unless compelling evidence forces us to conclude beyond a reasonable doubt that they lied or are mistaken or are irrational. In applying this principle of charity to the Constitution, it means presuming in favor of the interpretation that promotes justice and the general welfare over an interpretation that is unjust or harmful to the general welfare, unless compelling evidence forces us to abandon that assumption. The charitable interpretation of the Constitution is that it instructs us not to be cruel, to secure people's rights, including those not listed in the Constitution, and the like. So now I need to consider some objections to this view. The objection that carries the most weight, the one that can't simply be dismissed by any stretch of the imagination, is the fear of having unelected judges imposing their moral beliefs on the country through their judicial decisions. This is a significant argument for requiring that judges base their decisions on something other than their personal moral philosophies. At the same time, to tell judges that they should see the claim, "I was just following orders," as a legitimate defense for being an agent of injustice and cruelty has its own problems. There are reasons to require judges to give some weight to what others have written, but not so much that they can't stand in between an unjust and cruel legislature and their potential victims, particularly in the light of constitutional instructions that command judges to, in effect, do what is right. The moral fact theory doesn't tell judges to follow their whims and prejudices. It tells them to focus on the moral facts. People worthy of being appointed to the position of judge would have to recognize that they, too, are not a font of wisdom and virtue. The job requires appealing to and, in fact, giving a presumption in favor of the legislature, the opinions of other judges dealing with similar cases, and the writings of professional scholars on subjects relevant to the decision. A second objection to this moral facts account says that there are no moral facts. The person raising this objection asserts that morality is nothing but a matter of opinion, and nobody's opinion is better than any other's. This is a huge question. Almost every video on this channel addresses that question to some degree, directly or indirectly. But the first and most direct response to this objection, relevant here, says that, well, if there are no moral facts, then judges ought to interpret the law according to the original public meaning of the text. Can't be a moral fact. It's a flat-out contradiction to say that there are no moral facts and therefore there's an obligation to perform or not perform some action. A third objection that can be raised against the moral facts theory is that it violates the principles of democracy to have unelected judges make these types of decisions, that these types of decisions are to be made in the legislature by the people's chosen representatives. The first response to this objection is that any decision that renders a law unconstitutional is undemocratic by its nature. It's a statement that legislatures are not to be permitted to consider certain options. Well, one of the primary functions of the Constitution, the Bill of Rights, and the Civil War amendments is undemocratic. It's to prohibit legislatures from considering certain options. Their very purpose is to prohibit legislators from considering options that violate the rights to freedom of speech, that allow unreasonable searches and seizures, failure to provide just compensation, that inflict cruel punishments, or that deny due process and equal protection under the laws. Yes, it's undemocratic. It's supposed to be undemocratic. It's supposed to be a check against a tyranny of the majority. So these are my reasons for accepting a moral facts theory of constitutional interpretation. I'm curious as to whether you have any other objections that I might not have considered here. I would be pleased, eager in fact, to hear what they are and to try to give them their due consideration. Feel free to point me to them in the comments.